Welcome to this presentation on the EU labeling requirements for pre-packed food. After a brief introduction of the topic, we will look at the mandatory particulars that need to be affixed on your labels under the EU law and also maybe specifically under the laws of member states. Thirdly, we will look at some specific claims that are commonly found on products and hopefully address the way that they are regulated in the EU. And finally, we will look at some questions that were sent by participants and we will answer them. So firstly, let us introduce the topic. Under the European Union law, there is one major regulation that is known as the Food Information to Consumers Regulation. More specifically, regulation number 1169/2011. This so-called FIC regulation is really at the core of labeling requirements in the EU. It is a harmonized text, which means that this regulation applies in all 27 member states. And it is directly applicable. So whether you are in Germany or in France, all its provisions will apply. So whenever we look at the way that we have to label a product in France or in Germany, in the EU, we always firstly look at this text. So this text provides for the main mandatory particulars that must be found on all your packages for pre-packed foods. It also sets the conditions for the use of voluntary particulars, so particulars that are optional but that have to follow some principles when they are found on the label. And it also determines some categories of prohibited particulars. This regulation is not enough. The law of food products in the EU is very dense, so it is also supplemented by a number of different regulations and laws, soft law as well. If we look at what can also be found, we have different categories of text. Firstly, we have some specific text on specific labeling statements. So for instance, there is a specific EU regulation on nutrition and health claims, just as an example. We also have a text that regulates the labeling of some specific product categories. Those texts can be either EU texts, but they can also be national text. So for instance, under EU law, we have a directive on food juices. So this is a directive that will provide for some requirements that need to be filled by member states in terms of the labeling of fruit juice. And then if we look, for instance, at France, you know that France really enjoys its cheeses. And so therefore we have, of course, a decree that regulates the labeling of cheese. And finally, a third category where we have some texts that are adopted on the basis of that core regulation that I was mentioning, so the FIC regulation. So for instance, we have a regulation on the primary ingredient. This is a notion that we will look at later in the presentation. So just bear in mind that the FIC regulation also leaves room for the Commission to adopt some more specific rules on the labeling of products. So what are the different types of labeling statements that can be found on pre-packed foods? We can divide them into three main categories. Firstly, we have the mandatory particulars. So those will be found for all products. We will see that there are some exceptions for certain categories of specific products, but all foods, generally speaking, in the EU have to have a name, a list of ingredients, a quantity, etc. So those are mandatory. Secondly, we have some voluntary indications. So the the producer, manufacturer of the product may decide to make some claims, may decide to put some pictures or so-called graphic representations on the product. And so those are voluntary, but as we will see, rules need to be followed. And finally, we have some prohibited particulars. So we have named a few, but of course, a statement must not mislead the consumer. You cannot do abusive distinction. For instance, if you state, I don't know, that let's say a vegetable is vegan, that would fall under the abusive distinction category, because of course, all vegetables are necessarily vegan. And thirdly, as an example, we can name therapeutic claims. So you cannot claim that a product will cure cancer, for instance. So if we generally talk about the mandatory particulars, as we state on this slide, there is no leeway, meaning that when it comes to mandatory statement, everything that is stated under the regulation needs to be followed. So as we said, those mandatory particulars are mostly listed under the FIC regulation, but not necessarily. Also by some so-called horizontal text, meaning text that apply in the EU generally speaking. So for instance, there are specific mentions for organic farming products, and also under so-called vertical text, so text that will be more specific to a category of products such as cheese, food supplements, etc. Indeed, food supplements are considered as food under EU law, so this is why we are mentioning them here. We have provided an example of a label. So as you can see here, there is a name. Under the name, we can find a list of ingredients. We can see that the quantity is indicated, and also that there is a nutrition table. So this is just a brief overview of some mandatory particulars that you will find on products in the EU. There are also voluntary particulars, and those this time have more leeway, meaning that basically it can consist of pretty much anything. So it can be a text, a picture, a photo, a logo, the color of the packaging as well. Can be a voluntary particular. And as we state here, you do not have to put it on the label. It consists rather of a marketing statement. So if we look at this example, we have a logo, for instance, that states "Together Forever." Of course, this is not a mandatory particular. The producer has decided to state that those chocolate pies are the #1 in India. So you can use labels, for instance. It is rich with marshmallow, it is premium quality. So those are optional particulars. And finally, we have some particulars that are prohibited. So you should not, those mentioned should not consist of false information. They should not mislead the consumer. And also there are some specific regulations, as stated before, that will make some specific prohibitions. In particular, in this example, we have put a bottle of soy milk, and the use of the soy milk name is strictly prohibited under EU law. We know that since at least 2017, because the European Court of Justice has stated that traditional dairy names cannot be used for products that do not come from animals. So soya is plant-based, not animal-based. And also there is a regulation, and this regulation is Regulation 1308/2013. And under that annex number 7, there are provisions that prohibit the use of a denomination such as soya milk. So let's look firstly at mandatory particulars under EU law. So there are a number of what we call basic mandatory particulars. Those are listed here. You will find firstly the name of the food. The way that a food is labeled and named is regulated, and it should not be mistaken with the brand or the trade name of the product. We will take a closer look later in the presentation, but just bear that in mind already. Secondly, the label should include a list of ingredients. Again, the way that the ingredients are listed, the order in which they are listed, the way that you have to highlight allergens, and so on, is regulated. There are specific provisions on the list of ingredients. Thirdly, there is a mandatory declaration of intentionally used allergens. That is, there is a list of 14 notifiable allergens that are listed in the annex of the FIC regulation, and these need to be indicated. Fourthly, the quantity of the product must be indicated on the label. And we will also take a look at a very EU-specific rule, which is known as the QUID rule, which provides for an obligation to state the percentage of some ingredients in the list of ingredients when that ingredient is listed in the name of the product, for instance. Fifthly, we have the net quantity of the food. So it needs to be in the European metric system. It can be stated either by mass or volume. So again, we will take a more closer look later. Sixthly, we have the date of minimum durability or use by date. We also have any special storage conditions and or conditions of use that need to be stated. For instance, if the product needs to be kept in the freezer, this needs to be stated for the consumer. We also have to see the name of the person which is responsible for the labeling. This is very important because this determines the responsibility for any for the labeling, basically. So if the labeling is misleading, who will be responsible? Well, firstly, we will look at the name of the person responsible for the labeling. So we will just look at the label. So it can be either the company which is located in the EU or the importer. So this is very important. Then we have the country of origin of the product. If there is a risk of confusion about the real origin, the rules on the country of origin are very important. They can be quite complex, but we will take a closer look. If there are specific instructions for use, these need to be indicated. For instance, if the product needs to be warmed for 6 or 7 minutes, this is a mandatory label. We also have a specific mandatory particular for alcohols. So for a beverage which contains more than 1.2% of alcohol, the actual alcoholic strength by volume needs to be indicated. We have a nutrition declaration, which is found on products. We will see that there are exceptions, for instance, for alcohol. This is not found on alcoholic bottles in the EU. The batch number. Bear in mind that the batch number is not regulated by the FIC regulation, but by a directive. There are also other information that needs to be checked product by product. So for instance, if the product was frozen during the manufacturing process and is sold on the shelves in a defrosted state, this needs to be indicated so as to preserve the health of the consumer. And also always bear in mind that each country in the EU can adopt its own regulations of labels. So if the product is sold in France, you also need to look at French laws and regulations prior to labeling your products. As I stated that there are some foodstuffs which are exempted from certain indications. So I stated that, for instance, for alcoholic beverages, all mandatory particulars must appear, but there are two exceptions. The nutrition declaration is not compulsory, and the same goes with the list of ingredients. So of course, the producer may decide to put those particulars on the label, but it is not mandatory by law. There is also an exemption for reusable and indelibly marked glass bottles. So the name of the food, allergens, net quantity, the date of minimum durability, and the nutrition declaration are not compulsory. And there are also exemptions for packages with a surface which is lower than 10 centimeters square. So again, you have a list of particulars that do not have to be put on the label simply because the surface is too small. The regulations also state how the particulars have to be stated, their size, the color, the side of the packaging on which they must be affixed. This is all regulated very often. So for instance, we have rules on the readability and font size of the mandatory particulars. So the mandatory information must be easily visible, clearly legible, and also where appropriate, indelible. It must not be obscured or separated by other indications or images or any other interfering element. So put bluntly, the consumer needs to see the information. It needs to be clearly identifiable. There are also rules on the size font. So if we look at the annex of the FIC regulation, there are rules on the size. So as we have put on this slide, there is a minimum font size where the X, so we have circled it, is equal to 1.2 millimeter. And also there must be a significant contrast between the printed characters and the background. So for instance, if the background of your label is red, then the letters should not be red, they should be maybe black or something that is easy to read. There are also some rules on the way you calculate the area to determine the size of your font. And also we have mentioned here that thankfully we have many notices and guidelines by the European Commission on the way that some particulars need to be affixed. And so all these documents are very useful. They constitute soft law, meaning they don't have the same value as laws and regulations, but they are very, very helpful and can be used when the provisions are not very clear or are not very practically implementable. So if we take a look at more specifically at the mandatory particulars that we have already listed, we can firstly take a look at the name of the food. So what is the name of the food on an European label? The name of the food is strictly regulated, meaning that there is a definition under the FIC regulation of what the name is. So the name should be first and foremost the legal name, if it exists. By legal name, we mean the name of a food which is prescribed under EU law. For instance, there is a regulation that states that fruit juice is a juice from X variety of fruit with X particular characteristics. If there is no EU regulation, then maybe a national regulation defines what a product is. For instance, for cheese, we have definitions. So firstly, you should look at whether the category of products that you are selling is regulated, if there is a legal name, a legal definition. If there is no legal definition, no regulation, then the legal name should be the name defined by customs. By that, we mean a name which is accepted as the name of the food by consumers in the member state. For instance, ham is widely accepted by consumers as relating to meat from pigs. And failing that, if there is no legal name and no name defined by custom, then the name should be very descriptive, so as descriptive as possible. The name can be put anywhere, usually near the list of ingredients. And the name should not be mistaken with the fancy name of the product. It cannot be contradictory. The fancy name cannot contradict the legal name. And it is also different from the brand name and the trade name. So for instance, here the name would be spicy fermented Napa cabbage. That is a descriptive name, but you could use, for instance, Trader's Joe is not the name of the product. So we have provided 3 examples. So firstly, we have 100% pure squeezed orange juice. We have put it in French as well, because in France, we have a decree on fruit juice. And so since fruit juice is regulated, then here we have a legal name. Then we have a customary name. So we have a superior cooked ham in the cloth. This is as I said, widely accepted by customers, and there is no legal name for cooked ham. And finally, we have a descriptive name. For instance, Coca-Cola, which is very famous. Their legal name is sparkling soft drink with vegetable extracts. So the descriptive name, is sparkling soft drink with vegetable extracts. So there is a precise description of what the product is. Secondly, as a mandatory particular, there is the list of ingredients. The list of ingredients is always headed with the word ingredients or something to that effect. So for instance, list of ingredients, but the word ingredients must be found so as to help the consumer to identify the list of ingredients. It must be fragmented, meaning that the different ingredients in the product must be found. And they must be listed by order of importance by weight at the time of processing. So for instance, if water is added as an ingredient at the time of processing, maybe to make an orange juice, then the quantity, then the water must be stated as an ingredient. And if we take a look at the different names of the ingredients in the list, what you need to bear in mind is that those names of those ingredients and the way they are named follow the same rules as the name of the product. So for instance, if my ingredient is, let's say I have put orange juice in it, since it is a legal name, then I need to put the legal name in the list of ingredients. There are specific rules for additives and enzymes, for flavorings, nanomaterials, and for mechanically separated meats. So for instance, for additives and enzymes, which are ingredients, they need to be labeled either by stating the functional class and then followed by the name of the additive, or their functional class and the name of the additive with the letter E. So for instance, the functional class may be stabilizer, and then you can put E340 or the name of the additive. For flavorings, the name of the flavoring must be preceded with the word flavor or flavoring and then followed by its specific name. So for instance, vanilla flavoring. For nanomaterials, it's easily identifiable because you always find the name of the ingredients and then in brackets, the word nano. And for mechanically separated meats, you will find the word mechanically separated meat and the name of the animal species. Let's now take a look at allergens, which is important. There is an obligation to label allergens in the EU, and by that we mean the 14 notifiable allergens listed in Annex 2 of the FIC regulation. The Commission may also, from time to time, adopt acts on how to label the unintentional presence of allergens, and the allergens must be labeled regardless of their quantity. So which allergens should be declared? It's easy. We have a positive list. So for instance, peanuts, fish, eggs, mustard, milk, soybeans, sesame seeds, nuts, crustaceans, cereals containing gluten, celery, lupin. These are all considered under EU law as major allergens, and they should be found on the label. Not only must they be found, so they must be stated in the list of ingredients, but also they must be highlighted. So this is why in this example, we have a tangy cheese flavor corn chips, and we can find in brackets that, for instance, the tangy cheese flavor contains cheese powder from milk, buttermilk powder, wheat solids. So those are allergens, and this is why they are highlighted in black. So in this example, we have allergens which were used intentionally, so which is why they are found in the list of ingredients. But also there is a second square that the producer has decided to use, and here he highlights, careful. There is if you have allergies, this product contains milk, wheat, and gluten. And also it is made in a factory that also handles barley, soya, celery, mustard. So here the producers is also referring to allergens which were intentionally used in ingredients exempt from labeling. So processing aids and carriers. And also he indicates the risk of incidental presence of other allergens in its product. So I mentioned before the so-called QUID rule, or also more specifically described as the quantitative ingredient declaration. So I mentioned that this is a specific rule which is specific to the EU. So let's explain. So under the EU, you might find some products which in their name or maybe by the use of pictures will highlight the presence of certain ingredients. If that is the case, then the FIC regulation states that the percentage of that highlighted ingredients must be indicated in the list of ingredients. In this example, for instance, we have Italian penne pasta in tomato and basil sauce, topped with mozzarella and mature cheddar. A consumer who would read that name would expect to find tomato, would expect to find basil, mozzarella, and cheddar. And for that reason, those ingredients, because they are specifically stated in the name, must be indicated in the list of ingredients and be followed by the percentage that they represent. So we have 55% tomato sauce. We also have 30% pasta. We have a cheese mix, etc., etc. So the percentage of that name of the ingredients must be indicated in the name or in close proximity to the name or in the list of ingredients. And it corresponds to the quantity used except for volatile or dehydrated products. There are exceptions for ingredients which are used in small doses for flavoring purposes. And those exceptions are all stated under the FIC regulation. Also bear in mind, we have provided a link, but there is also a communication from the Commission on the application of the QUID rule, which is very useful because it provides some examples to help understand the rule. So this is the notice on the application of the QUID rule. And here, for instance, there is an example. So if we look at chili con carne, a consumer would expect in chili con carne to find meat. So even though the name is indicated not in English, still it is widely accepted that such a recipe contains meat. And so therefore, under the QUID rule, the percentage of the minced meat must be indicated. The net quantity of the food is also important. It is also regulated. So the unit to be used must be for liquids liters, centiliters, or milliliters. If the food product is a solid, then it must be expressed in kilograms or grams. Also, the weight of the quantity must appear in the same field of vision as the name of the food, so as to be identifiable right away by the consumer. We refer, of course, to the name of the food, not the trade name. So still bear in mind the distinction. And there are also rules on the way that the quantity must be calculated and indicated. So for instance, for the net quantity must be expressed on each package unless the quantity is visible from the outside. So for instance, here we have to write 3 times that each individual product in the pack is 100 grams. But otherwise, the total net quantity and the total number of individual packages must be indicated if the product is not visible from the outside, which is why here we have indicated only once 300 grams. One of the mandatory particulars that we mentioned is the date of minimum durability, or the use by date. It can be presented in different ways. So the date of minimum durability must be expressed as best before and then the recommended time frame. So if that time frame is under 3 months, the date is expressed in days or months. If it is comprised between 3 months and 18 months, it must be expressed in months or years. And if it is over 18 months, it is expressed in years. And the use by date must contain a specific mandatory deadline. So it must be a specific date. The use by date is, of course, used for products that can expire very quickly, that are, for instance, yogurts or ice creams. So day, month, year. And also you can use a reference to where the date is given on the labeling. So for instance, the date can be found at the bottom of the product. The time limit for consumption after opening the packaging, if this is necessary for the proper preservation or use of the food, must be indicated. So for instance, to be consumed within 5 days after opening. And also, if the product is meat, frozen meat preparation, or frozen unprocessed fishery product, the date of freezing or first freezing must be indicated. And this is under a different regulation, under the so-called hygiene regulation. We also have storage conditions and or conditions of use that must be indicated. So in this example, we can see perishable, keep refrigerated. So if the food requires a certain manipulation by the consumer, this should be indicated. If the food must be stored in a specific place, in a specific way, this also must be indicated. So let's take a look at the name or business name and address of the food operator. Briefly, before, we have stated that this is very important. So the name or business name and address of the food business operator determines the responsibility for the labeling. So under Article 8, it is clearly stated that the food business operator, which is responsible for the food information, is the operator under whose name or business name the food is marketed. Or if that operator is not established in the EU, then it is the importer into the union market. So in this example, the product was produced, manufactured by a Korean company, but it was imported by a French company. And so therefore, the importer into the EU would be responsible for the food information. And for instance, if there is a misleading statement, then the responsibility falls on the importer. The country of origin is important, and the rules can be a bit complex. The country of origin is not always mandatory. It is mandatory in 4 cases. So under the FIC regulation, there are 2 main cases that are mentioned. Firstly, the country of origin should be stated where when it is not found, it could mislead the consumer as to the true origin or provenance of the product. And secondly, where the origin of the primary ingredient differs from the origin of the product as a whole. We will explain what this means. Thirdly, under specific European regulations, the origin may be compulsory. For instance, such is the case for olive oil. We have an EU regulation that requires that the origin be indicated. And fourthly, under French law, for instance, but the same goes with other member states, there may be specific national regulations providing for the mentioning of the origin. So for instance, there is a French decree for the origin of meat. So very often, I mean, not very often, but in all cases, the origin of meat must be indicated. So we have provided this Article 26 of the FIC regulation, which basically states what I have just said. So we can maybe not spend too much time on it. Let's focus rather on the primary ingredient. So what do we mean by primary ingredient? The primary ingredient is the ingredient which is either present in the food at a level of more than 50%, or it can be the name which is usually associated with the sales name and for which a quantitative indication is required in most cases. In other words, in the mind of the consumer, when you hear a name, so chili con carne, you would expect to find meat. For pesto, the consumer would expect to find basil, and so on and so forth. So where the country of origin or place of provenance of the food is indicated, but it is not for the primary ingredient, then you must also indicate the origin of the primary ingredient. So let's maybe take an example. Here we have a Greek-style yogurt. This Greek-style yogurt was produced in the UK, but also we find the word Greek. So this Greek-style yogurt should specify its origin. So how can we identify the primary ingredient, which is usually associated with the product? There are 3 criteria. First criteria, the ingredient is associated with the name of the food. Second criteria, the consumer perception. So the name of the product is associated with a particular ingredient. For instance, in apple pie, you expect to find apples. And also another criteria is that very often, since that name appears in the name of the product, or maybe you will find a graphic representation on the label, very often that rule that we talked about, the quid rule, would apply, meaning very often you would need to indicate the percentage in the list of ingredients. And this is usually an indication that that ingredient is a primary ingredient. So here we have an example. This product is made in the UK, so this is the origin of the product, but with the stem ginger, which is Australian. So the stem ginger here is the primary ingredient, which is why the origin is indicated. The origin of the ingredient must be indicated in the same visual field as the origin of the food. So for instance, next to it. It must be in the same size, the same color, and the same font as the one used for the ingredient list. And the origin of the primary ingredient may not be less than 75% of the size of the font used to indicate the origin of the food. And this is regulated by the so-called primary ingredient regulation that you can, of course, take a look at. So here, for instance, another example, this product is from Italy. This product consists of peeled tomatoes in tomato juice. So the primary ingredient of this product is tomato, which is why the origin of the tomatoes is also indicated. So the tomatoes also come from Italy. So basically the idea is to be transparent with the consumer. Let's now turn to the instructions for use. The instructions for use must be indicated in such a way as to enable appropriate use to be made of the food. So for instance, here in this example, we have using directions. So you should add 5 grams of the product in 1 liter of hot liquid, etc., etc. So this is just an example, but I think you understand what is meant here. Then the nutrition declaration. This is also quite complex, so we can maybe spend some time on that specific topic. What are the big 7? The big 7 are the big 7 nutrients that must be found in the nutrition table. So we have energy, fat, saturates, carbohydrates, sugars, protein, and salt. There is a definition of what is meant by salt. By salt, we mean the salt equivalent content calculated using a specific formula. And the FIC regulation also provides for rules as to the way that these nutrients must be calculated, the way that their quantity must be expressed. The quantity must be expressed per 100 grams or per 100 milliliters. Also, the percentage of reference intakes for vitamins and minerals must be indicated. So the rules are detailed in a number of articles of the FIC regulation and also under 4 different annexes. On top of these big 7 nutrients that must be labeled, there are also some voluntary nutrients that may be indicated. Those are monounsaturates, polyunsaturates, polyols, starch, fiber, vitamins, and minerals, provided they are present in significant quantities. Just bear in mind that there is a positive list, meaning an exhaustive list of what may be indicated. Other substances may not be indicated. There is also an example provided under the FIC regulation of the way that the nutrition declaration must be presented. So this is very useful. And also there are optional modes of expression. So you may express by portion or unit of consumption, and also using the percentage of reference intake of energy and nutrients other than vitamins and minerals. The presentation, again, there are modalities that are detailed under the regulation. So they may be indicated in a table or linear form, provided that space is limited. All the particulars must be in the same field of vision. Their character size should be of more than 1.2 millimeters. And also there are statements that may be also added near the nutrition declaration. So those are, firstly, we have the salt content is exclusively due to the presence of sodium naturally present in the food, and also contains negligible amounts of. So whenever in doubt of the way that the nutrition table, or if it is in linear form, the nutrition declaration must be drafted. We again have a number of guidance documents which are made by the European Commission and also by some national authorities. Let's take a look at alcohols, so beverages which contain more than 1.2% of alcoholic strength. As I stated, for these products, you do not need to find a nutrition table, but you also have the rule of affixing the alcoholic strength by volume, and this should be expressed in a percentage. So we have an example here. You can see that it has been indicated. Also, there is a requirement to put a batch number on your label. This is not provided for under the FIC regulation, but under a directive. So by a lot or by batch of sale, we mean batch of sales units of a food which is produced, manufactured, or packaged under practically the same conditions. And it is always preceded with the letter L, so it's easily recognizable. So there are specific claims that may be made on products. Sometimes they are regulated, sometimes they are not, but let's take a look at them. Of course, one claim that is found sometimes is the GMO or non-GMO claim. And under the EU and under French law, it is regulated. So it is compulsory to indicate the presence of GMOs on a product. Of course, bearing in mind that not all GMOs are authorized in the EU, so they must be authorized first and foremost. And then the way they must be indicated is regulated. So the presence of GMOs must be indicated using specific wording. So one can either state genetically modified, or one can state contains genetically modified and then the name of the genetically modified organism. So such can be the case, for instance, for corn. Or one can use produce from genetically modified, the name of the organism, or contains the name of the ingredients, produced from genetically modified, and then the name of the organism, when the product contains GMO derivatives. So such can be the case for soybean paste, for instance. If a food contains more than one GMO ingredient, then the statement must be provided for all the ingredients concerned. For prepacked foods, the statement must appear either in the list of ingredients or in a note at the bottom of the list of ingredients, and of course in an identical font. And if there is no list of ingredients, that can happen, it must appear clearly on the label. In France, we have specific rules on the use of GMO-free claims. Those rules are found in a decree dated 2012. And it applies only for specific categories of products. So it applies to ingredients of plant origin, for instance, flour, starch, or lecithin. And also it applies to ingredients of animal origins, such as meat and fish, or milk and eggs. And depending on the ingredient, the statement is not the same. And the rules for using the statement are not the same either. So for ingredients of plant origin, one may use the statement GMO-free or non-GMO, provided that the ingredients are obtained from raw materials which contain a maximum of 0.1% of GMOs. And also that presence of GMO must be incidental and technically unavoidable. Only if these requirements are fulfilled may you use such a GMO-free or non-GMO claim on your product. For ingredients of animal origin, so for instance, for let's say milk, sometimes on bottles of milk, you may find statements such as fed without GMOs and then stating under 0.1%. Or you may find a second authorized claim, which is from animals fed without GMOs, inferior to 0.1%. these statements may be used, and that exact wording has to be followed, provided that the feeds are obtained from raw materials which contain a maximum of 0.1% of GMO, and provided that the presence of the GMOs is incidental and technically unavoidable. So as you can see, those are very strict rules, and while GMO-free claims are voluntary, the way that they are used is very heavily regulated. And also, this statement may not be used to designate ingredients which are derived from plants of which no genetically modified species has been authorized for placing on the market in the EU. So of course, the GMO must be authorized on the EU market for such a claim to be made. There is, of course, a trend of using organic claims. The European consumers are very sensitive to such claims, and so such claims are regulated. And we may take a closer look at the way that organic claims are regulated when the prepacked food is imported from a third country. So, for instance, imported from Korea. The rules that we will detail now are applicable until the 31st of December 2026. Until then, there may be new negotiations of trade agreements between the EU and Korea. So the rules may change, but for now, they are as detailed here. So currently we have a regulation on organic production and labeling of organic products, which states that when an organic claim is used on a product, then certain labels must appear and certain conditions must be followed, or sometimes the labels and statements may be optional. So let's take a look. So if an organic claim is made and the product contains at least 95% by weight of organic agricultural ingredients, which comply with EU organic rules, then there is an option to use the EU organic production logo, which you can see here, that green logo. If that logo is put on the product, then there is a mandatory mention of the origin of the agricultural raw material, which must appear in the same field of vision as follows. So one may state EU agriculture when that agricultural raw material is produced in the EU. If that is not the case and that material is produced in third countries, one must use agricultural non-EU. When part of the material is produced in the EU and another part in a third country, then the statement that must be used is EU non-EU agriculture. So if you use that logo, then you must add those words on your products. And also, in any case, there is a label that must be attached. There is a statement that must appear on the label attached to the product. So that is the code number of the inspection body to which the operator who carried out the last production or preparation operation belongs. So for Korea, this information is provided by the Korean inspection body. And it basically confirms the equivalence between the EU organic rules and the Korean organic rules for their specific product. So that's for products which contain at least 95% of organic ingredients. For products which contain less than 95% and which have an organic claim, the logo may not be used, so it is strictly prohibited. But the label that we mentioned, the code number of the inspection body that we mentioned must appear. Recently, we also find a lot of clean labels, such as no additives, for instance. So these are not regulated. You will find no specific regulation on clean labels. The clean labels may, for instance, consist of claiming that there are no additives, no flavorings, no processing aids, no added preservatives. So when using such statements, one should think about the main function of the substance which is used, and also wondering what's the main reason for using the substance is in the first place. But in any case, in terms of labeling, even though this is not a mandatory particular, this is a voluntary claim, there are rules that must be followed. So if the negative claim is not covered by a specific text, the negative claim and I mean the clean label statement must firstly not create a risk of confusion by deceiving the consumer, creating ambiguity. It must not create undue distinction. So, for instance, if one claims that the product contains no preservatives, and such is the case for all products of that category, then the statement may not be used. For instance, alcohol would not contain preservatives, so saying no preservatives would serve no purpose and would distort competition. One must not slander competitors and their products. So this is quite important. Of course, the risk is mostly from your competitors who might decide to sue you. And also the statement must not put the consumer at risk. So when using clean labels, one needs to be careful and bear these rules in mind. Another trendy claim is the gluten-free claim. This time, this claim is regulated. There are two statements that are regulated, gluten-free and very low gluten. The regulation dates 2014 and provides the requirements for claiming that there is no gluten or very low gluten in the product. And the rules are very strict. They are found in an annex to the regulation. So for instance, for gluten-free, this statement may only be used provided that the food contains no more than 20 milligrams per kilo of gluten. And for the very low gluten claim, the food must consist of or contain one or more ingredients made from wheat, rye, barley, oats, or their crossbred varieties, and they must have been specifically processed to reduce the gluten content, and the food should not contain more than 100 milligrams per kilo in the way that it is sold to the consumer. So there is very few leeway for the use of these particulars. The regulation must be followed strictly. Vegan, halal, and kosher logos are interesting because for them we don't really have regulations. However, we do have the Codex Alimentarius, which provides some basic guidelines for the term halal. So the Codex Alimentarius, as you know, is a collection of internationally recognized standards and guidelines, which is published by the Food and Agriculture Organization. So this firstly is a really good indicator of whether you may use such a claim or not. And also in the EU, there are private certifications, and each country may have its own rules on the use of these logos. So for halal and kosher products, the products must be certified by a recognized private company or by an authoritative religious body. So in that case, the presence of the certification body's logo must be there. And for vegan products, while the product may be certified by a recognized private company, The food operator may also demonstrate that the product does not contain any ingredient of animal origin. So basically, to summarize, the statement must be true. So a vegan claim is a voluntary claim, but in the event of a control by the authorities, one must be able to demonstrate that no meat is found in the product. Nutrition claims. Nutrition claims are regulated, and that same regulation also provides the rules for health claims. Nutrition claims may only be used provided they are found in a positive list, which is found under the annex to that regulation. So positive list means everything that is not allowed is prohibited. So any claim on a list can only be used if the conditions of use are met. So for instance, using sugar, you may use a sugar-free statement provided that the rules are strictly followed. So here we have the list of nutrition claims that are authorized under EU law. We have an energy-free claim, a fat-free claim, saturated fat-free, sugars-free, sodium-free, or salt-free. And as we may see, there are specific conditions. So for instance, for fat-free, a claim that a food is fat-free and any claim likely to have the same meaning for the consumer may only be made where the product contains no more than 0.5 grams of fat per 100 grams or 100 milligrams. So as we see, this is very regulated. And then we have health claims. So health claims are slightly more complex because, again, we have a positive list principle. So only authorized nutrition, only authorized health claims may be used. So by authorized, we mean that EFSA, which is the European Food Safety Authority, so the claim must have been examined by EFSA, and then the Commission must have authorized the claim. If such is the case, then the claim is on a positive list and it may be used, provided, however, that the claim also complies with the conditions of use and the provisions of the aforementioned regulation. So one should refer also to the European Union Register of Claims, which provides the exhaustive list of authorized health claims in the EU. But there are also some particular rules in 3 cases. So, for instance, some references to the general health status and health-related well-being may be made, provided that the rules under Article 10.3 of the regulation are followed. So, for instance, we mean by references to general health status and health-related well-being, for instance, the claim detox. This is really a very general statement. And for such a detox claim to be used, that claim must be accompanied by a specific authorized health claim. Secondly, we have a non-conforming trademark or trade names. So by that, we have basically a number of names that were not conforming prior to a specific date. So prior to the 1st of January 2005, well, these names may be used until the 19th of January 2022 as an exemption. And then we have so-called on-hold health claims. So basically, in 2010, there was an evaluation of about 2,000 claims that was put on hold by the European Commission, simply because there was such a large amount of claims that were filed for examination and assessment. And therefore, the Commission decided that for all the claims that were not assessed by EFSA, by the European Food Safety Authority, a transitory regime would apply. So As of today, these claims may be used, provided firstly that a request for authorization has been filed prior to the 19th of January 2008, and secondly, provided that the claim complies with the rules of the regulation. So for instance, if you make such a claim, you would look at the register of on-hold claims, see that a company filed a request for authorization, and then you may use it provided that you can provide proof in the event of control that your claim is true. So of course, allegations must not mislead the consumer, they must be true, and therefore you should be able to justify to authorities that your claim is not false. So finally, we will address some questions from participants which were sent. We have received a question on the possibility of using the expression vegan on a package without any certificate. The answer is very clear. Yes, it is possible. As we said, vegan products may be certified by a recognized private company, but this is an option. The vegan claim so far is not regulated, or the food operator can demonstrate that its product does not contain any ingredient of animal origin. So, as I said, in the event of control, the operator must be able to prove that the statement is not false. If the food operator can prove that the product is in fact vegan, then the expression vegan may be used. Secondly, a question on the use of organic logos. So the question is, in the case of a Korean operator having the right to use the USDA organic logo or the Korean organic logo on its product, the question is, are these logos also valid in the EU? The answer is no, because as previously stated, the logo that may be used depends on the percentage of organic ingredients in the product, and the logo that may be used is only the EU organic logo. What are the conditions of use of these organic logos in the EU? Well, there are none. You may not use USDA and Korean organic logos in the EU. And how can the equivalence of these logos be obtained in the EU? So as stated, the use of organic logos is either optional, so if the product contains more than 95% of organic ingredients, then the EU organic production logo may be used, or if the percentage of organic ingredients is under 95%, then that logo may not be used. It is strictly prohibited. And this equivalence between European and Korean organic rules will stay in force until the 31st of December 2026. As stated, it is always mandatory to indicate on the label attached to the product the code number of the inspection body, which is delivered by the European Commission. And this information is provided by the Korean inspection body. And this code confirms the equivalence between the European and Korean organic rules for the product. So we have provided a link to the list of third country inspection bodies and that of Korea, of course. Using gluten-free logos and the expression gluten-free is regulated as previously stated. So gluten-free products may be certified by a recognized private company. But in any case, the food operator must comply with the requirements of Regulation 828/2014. So the statement gluten-free may only be made where the food as sold to the final consumer contains no more than 20 milligrams per kilo of gluten. And finally, we have a question on the conditions of using the name of lactic acid bacteria. So for instance, lactobacillus, and the expression probiotic. So Live microorganisms which are used as ingredients must be labeled in the ingredient list. And ferments may be indicated, or the generic names such as lactic acid bacteria or the Latin name Bifidobacterium may be used. The expression probiotic is considered as a health claim under EU law, and so far it has not been authorized by the European Commission for all foods. It has been so for specific products, however, mainly that is for yogurts or fermented milk, provided that the yogurt or fermented milk fulfills the conditions stated under the Registry of Claims. So to bear such a probiotic claim, the yogurt or the fermented milk should contain at least 10 colony forming units of live starter microorganisms per gram. Well, thank you very much for following this presentation, and we hope that this has answered all your questions. Thank you.